We're expecting an announcement about Kathleen Folbigg.
And if she were granted parole, she'd be due for release in 2028. There have been numerous legal proceedings in this matter, numerous appeals and applications to the High Court. And in 2018, His Excellency at the time, Governor Hurley, on my recommendation, directed an inquiry be undertaken by former District Court Chief Judge Reg Blanche into the convictions. The basis of that earlier inquiry was some doubt that had arisen from a theory that there had not been anywhere in the world more than 3 deaths from natural causes in the one family. After an extensive public inquiry, Commissioner Blanche found that there was no doubt about Ms Folbigg's guilt, and indeed he thought that the evidence before him actually reinforced his view that Ms Folbigg was guilty of those 4 homicides and that malicious infliction of harm. At the inquiry, there was evidence about a mutation of a gene known as CARM2, but there was disagreement between the experts as to the effect that mutation may have. And there was a Canberra team that had one view and a Sydney team that had another view. After that inquiry report in mid-2019, a paper was published in Europace, which is the journal of the European Society of Cardiology. And it was a paper by 27 scientists who looked at the mutation of this gene in Ms Folbigg and her 2 daughters. And the conclusion of this paper was that this mutation was a reasonable explanation of the death by natural causes of Ms Folbigg's two daughters, and indeed a likely explanation for those deaths. In March 2021, Her Excellency received a petition from Ms Folbigg's lawyers asking for the exercise of the Royal Prerogative of Mercy and the grant of a pardon. After that petition was received, a series of further supplementary submissions and evidence was received from time to time up until about December last year. Presented with this evidence, I, as Attorney General, had a number of choices of recommendations to make to Her Excellency. One of those choices would be to dismiss the petition altogether. That would not be a proper option. I can well understand why members of the public may shake their heads and roll their eyes in disbelief about the number of chances that Ms Folbigg has had to clear her name, and why does the justice system allow someone who's been convicted of homicides, multiple homicides, yet another go. But the evidence clearly, in my view, reaches the necessary threshold for some kind of intervention. It certainly rises to the level of question or doubt that's referred to in the statute about appeals and reviews in this sort of matter. That doesn't mean that I formed any view as to the guilt or innocence of Ms Folbigg, nor as to whether there is any reasonable doubt about her conviction. But certainly there is enough of a question or doubt that this new scientific evidence raises that justifies some form of intervention. And the fact that this evidence has come to light after the last inquiry obviously is not the fault of Ms Folbigg or her lawyers, so she can't be blamed for that, and that can't be held against her in this application. So then the question is, what sort of form should the intervention take? And Ms Folbigg's lawyers have asked for a pardon. I've recommended to the Governor that a pardon not be granted because I don't think it's appropriate against the backdrop of what has happened, nor fairness and transparency, that there simply be a pardon. We've had a trial by jury in the public space. We've had numerous applications in court. We've had a very public inquiry. It would be undermining confidence in the judicial process and our justice system if I, as a politician, recommended behind closed doors to the Governor that there be a pardon, no matter how compelling Ms Folbigg's lawyers say the evidence is. That evidence may well be compelling. It may well transpire that's what the inquirer finds, or he may find that it is not compelling. But that's a matter for the inquirer, who I should have mentioned will be the Honourable Tom Bathurst, ACQC, the recently retired Chief Justice. Obviously an eminent jurist, someone particularly qualified for this role, and someone whom I have every confidence will deal with this inquiry in an expeditious and efficient and ultimately a fair manner. So a pardon is not appropriate because the evidence does need to be tested, even if its protagonists say it is compelling, but it's not appropriate that it be tested behind closed doors. I was invited by the Academy of Science, the Australian Academy of Science, to have a private meeting, a private briefing to run through the evidence and be told why it is so compelling. But given the way our justice system operates, that wouldn't be appropriate. Justice in New South Wales has to be transparent and open. If people are to be confident in our justice system, they have to see it in action. Open justice is a key underpinning of our justice system. So in the end, just a pardon, a simple pardon, without that open, transparent process would not be appropriate. So then the choices were between a direct reference to the Court of Criminal Appeal or a public inquiry. I took some time to consider which option was the best option and took advice on that. And I've opted to recommend a public inquiry. This is more likely to get to the bottom of this scientific evidence than an adversarial process before the Court of Criminal Appeal. It will also afford the opportunity for other parties, such as Craig Folbigg, Ms Folbigg's ex-husband, if he so chooses and if he's allowed to do so, to be represented and make submissions. So I have recommended to Her Excellency that there be a public inquiry. This has been a difficult decision, but in the end, I think there was no other option but to have some kind of renewed chance for Ms Folbigg, given the way this scientific evidence has emerged and the nature of this scientific evidence. Of course, it will weigh on all our shoulders the pain and suffering that the Folbigg family has been through, particularly Craig Folbigg. This is a man who has lost 4 children over a 10-year period, who has seen his wife convicted of their homicides, who's had to relive it all again through a public inquiry in 2018, 2019, and will have to go through it yet again in 2022, this time with Commissioner Bathurst. And I am truly sorry for the pain that Mr Folbigg suffers and for his family because of this re-traumatisation. I have spoken to Mr Folbigg a little while ago and also to Ms Folbigg's foster sister, Ms Leah Bowen, to explain my decision to them. And I think all of us just can't imagine what this family has been through, and whatever the outcome of this inquiry, it is an extraordinary tragedy. There have been some commentary about why it's taken so long to make a recommendation to the Governor when the petition was first presented to the Governor in March 2021. That's because Ms Folbigg's lawyers have chosen not to rely just upon the materials supplied at the time, but have continued to provide supplementary material up until as late as December 2021. I say that not to criticise them in any way. It's their choice how they want to present their case and what they want to rely on and the grounds upon which they wish to rely. But it is the major explanation for why we are sitting here or standing here in May 2022, 14 months after the March 2021 petition. So look, that's where we are.
You're just listening to the New South Wales Attorney-General there launching a second public inquiry into the conviction of Kathleen Folbigg over the deaths of 4 of her infant children. Kathleen Folbigg spent nearly 2 decades in jail, but as you heard there, new evidence is suggesting a gene mutation could be a responsible explanation of those deaths by natural causes for her daughters.